Hello everyone, and welcome to Internet Law Review. For today's story, we have the case of United States versus Davis. This is a United States Supreme Court case that is once again trying to determine what the phrase crime of violence or its equivalence means in a federal statute. When Congress passes laws, they often put in sentence enhancements for certain violent crimes, but in some situations they put in a more generic clause that refers to crimes of violence in general or something similar to that. And this is the situation here. So the Supreme Court is again trying to interpret one of these provisions in a law and determine whether or not the conduct of the defendants here qualifies as a crime of violence for the purpose of this statute based on its particularized phrasing. So let's see what the facts are, see what the law is, and see how the Supreme Court says this should be analyzed. Let's get started. Respondents Maurice Davis and Andre Glover were charged with multiple counts of Hobbs Act robbery and one count of conspiracy to commit Hobbs Act robbery. In case you're interested, Hobbs Act robbery is simply a robbery that occurs in interstate commerce. So basically, if you go rob a convenience store or a Walmart or something like that, it's going to involve interstate commerce. So not only can the state come after you for your violation, but the federal government can come after you because you robbed a store which was located in interstate commerce, which is pretty much to say every store in existence. They were also charged under 18 U.S.C. 924, which authorizes heightened criminal penalties for using, carrying, or possessing a firearm in connection with any federal crime of violence or drug trafficking crime. Crime of violence in this statute is defined in two subparts, the Elements Clause and the Residual Clause. The Residual Clause in turn defines a crime of violence as a felony that by its nature involves a substantial risk that physical force against a person, property of another, may be used in the course of committing the offense. A jury convicted the men on most of the underlying charges and on two separate gun-related charges for the brandishing of a firearm in connection with their crimes. The Fifth Circuit initially rejected their arguments that this residual clause is unconstitutionally vague, but on remand from the U.S. Supreme Court, in light of Sessions v. Diama, the Circuit Court reversed course and held that the Guns Clause's residual clause unconstitutional. The Circuit Court then held that Mr. Davis and Mr. Glover's convictions on the gun-related charge for robbery as a predicate crime of violence could be sustained under the Elements Clause, but that the other count, which charged conspiracy as a predicate crime of violence, could not be upheld because it depends on the residual clause. So in this particular criminal law, we have what we often have in law. We have a list of specific examples and then a provision that says, and other stuff in some sort of phrasing. So basically Congress and most state legislatures, when they're drafting these things, don't think they can think of everything, and fair enough. So basically what you normally do is you list a list of specific examples and then you say, and other things that are like this in some sort of phrasing. And the idea is that we're going to give you a list of specific things and other things that we're not going to name that are like those things that we've listed, so we can sort of define this thing. And so the question here is, in this particular situation, is this residual clause written in such a way as to allow for that normal reading, or are there more specific problems for this particular statute that do not allow for that in this particular case? Let's see what the Supreme Court had to say. Held. The section of the law dealing with the residual clause is unconstitutionally vague. In our constitutional order, a vague law is no law at all. The vagueness doctrine rests on twin constitutional pillars of due process and separation of powers. This court has recently applied the doctrine in two cases involving statutes that bear more than a passing resemblance to this statute's residual clause. Johnson v. United States, which addressed the residual clause of the Armed Career Criminal Act, and Sessions v. Diama, which addressed the residual clause of 18 U.S.C. Section 16. The residual clause in each of those cases required judges to use a categorical approach to determine whether an offense qualified as a violent felony or crime of violence. Judges had to disregard how the defendant actually committed the offense and instead imagine the degree of risk that would attend an idealized ordinary case of that offense. So if you're looking at a categorical approach, you treat the case categorically, which is to say as an absolute. So basically in that situation, you're looking to say every crime of robbery, for example, is the same. We're not going to look to the specific facts of this particular case. We're just going to say that all cases of robbery are like each other in a particular way, so we're going to treat them all the same. In a non-categorical approach, in an individualized approach instead, you'd look at the individual elements of the case in front of you. So the question for categorical versus non-categorical, are judges supposed to look at robbery, for example, as sort of a meta of all robberies? Or are they supposed to look at this particular robbery? So let's see how that worked out. The court held in each case that the imposition of a criminal punishment cannot be made to depend on a judge's estimation of the degree of risk posed by a crime's imagined, ordinary, or categorical case. The government and lower courts have long understood this section to require the same categorical approach here. Now the government asks this court to abandon the traditional categorical approach and hold that the statutes command a case-specific approach that look at a defendant's actual conduct in the predicate crime. The government's case-specific approach would avoid the vagueness problems that doomed the statutes in the prior cases in Johnson and Diama, and would not yield to the same practical problems and Sixth Amendment complications that a case-specific approach under the Armed Career Criminal Act and Section 16 would, but this approach finds no support in this statute's text, context, and history. So the Supreme Court is saying, look, in other statutes that we've interpreted this or similar language, we've said the categorical approach isn't appropriate, but you can do a case-specific approach. And the government here is saying, well, if that's the rule, then let's do an individualized approach here as well. The Supreme Court has said, while that strategy worked in other contexts, it doesn't work in this context because the statute's text are such that we can't do that kind of construction. So the individualized case analysis is right generally, government, but unfortunately this particular statute's written, so even that won't work here. This court has already read the nearly identical language of Section 16b's to mandate a categorical approach. And what is true of 16b seems at least as true as to this statute. The government claims the singular term offense carries a generic meaning in connection with the elements clause, but a specific act meaning in connection with the residual clause. But nothing in this section rebuts the presumption that a single term offense bears a consistent meaning. And that's fair enough. Normally in the same statute, when you use the same word in the same statute, it means the same thing. That can of course be overcome. It's not always true. But normally in law, we presume that when legislatures are writing down the same word in the same statute, they mean it to have a consistent meaning. That may or may not apply to other statutes they've applied in the past, but at least with respect to something they're passing all at once, we assume they have a consistent meaning unless the text would suggest otherwise, and that's what they're talking about here. The court continues by saying this reading, the reading we're giving here, is reinforced by language of the residual clause itself, which speaks of an offense that, by its nature, involves a certain type of risk, which would suggest a more categorical approach. The categorical reading is also reinforced by the statute's role in the broader context of the Federal Criminal Code. Dozens of federal statutes use the phrase crime of violence to refer to presently charged conduct. Some cross-reference another statute's definition, while others are governed by the virtually identical definition in Section 16. The choice appears completely random, which is never a positive sign for a law when you don't know which one to do. It suggests you're making a choice that you shouldn't be making because the law should be clearer than that. The court continues. To hold that Section 16b requires the categorical approach, while this section requires a case-specific approach, would make a hash of the Federal Criminal Code, and makes sense. Again, when you're dealing with essentially identical wording, you would tend to think Congress meant the same thing, all else being equal. The section here's history provides still further evidence that carries the same categorical approach as that commanded in 16b. When Congress enacted the definition of crime of violence in Section 16 in 1984, it also employed the term in numerous places in the Act, including this section here. The two statutes, thus, were originally designed to read together. Again, when Congress is passing the same thing at the same time, we tend to assume they meant the same thing, and it's a consistent reading. The court continues. And when Congress added a definition of crime of violence to 924 in 1986, it copied the definition from Section 16 without making any material changes to the language of the residual clause, which would have been a bizarre way of suggesting that the two clauses should bear drastically different meanings. Yeah, if Congress is stealing language from one place and putting it in another, we can reasonably assume they meant whatever it meant here to mean the same thing here. Fair enough. Moreover, the section at issue here originally prohibited the use of firearm in connection with any federal felony before Congress narrowed the section in 1984 by limiting its predicate offenses to crimes of violence. The case-specific reading would have gone a long way to nullifying that limitation and restore the statute's original breadth. Relying on the canon of constitutional avoidance, which is a general default rule that if you can avoid the constitutional issue, you should, the government insists that if a case-specific approach does not represent the best reading of the statute, it nevertheless the court's duty to adopt any fairly possible reading to save the statute from being unconstitutional. But It's doubtful that the canon could play a proper role in this case, even if the government's reading were possible. This court has sometimes adopted the narrower construction of a criminal statute to avoid having it hold it unconstitutional if it were constructed more broadly, but it's not invoked the canon to expand the reach of a criminal statute in order to save it. To do so would risk offending the very same due process and separation of powers principles on which the vagueness doctrine itself rests, and would sit uneasily with the rule of lenity, teaching about ambiguities about a criminal statute's breadth should be resolved in defendant's favor. So the rule of lenity is a very well understood and well-known construction of criminal law. It's basically saying rule of leniency, if you like. It's saying that if a statute can be understood two different ways, you always interpret it in the defendant's favor. You always interpret it to cover less criminal conduct. You always interpret it in a way that makes more things permissible. The idea that if things are supposed to be illegal, it should be clear. And so if you can read it two different ways, the rule of lenity says, read it the narrower way. Give the defendant every benefit of the doubt, and that's a classic rule of criminal law construction. Affirmed in part and vacated by a non-traditional 5-4 split. In this particular situation, it is Gorsuch who's writing the opinion on behalf of the liberal part of the court, and it's Kavanaugh who's writing a dissent on behalf of the minority part of the court. So this is a 5-4 decision. Well, this seems like a pretty interesting and pretty standard statutory construction law. Basically, you're trying to decide if this residual clause can be interpreted in a way as to be a vagueness problem or not. And vagueness is a bit of a subjective call when it comes to constitutional law. You're trying to determine whether or not a statute gives fair notice to the public and to a potential defendant as to what the law prohibits. And obviously that can be a little bit difficult sometimes because laws can be somewhat vague and you don't want to strike down every law. So the question of when vagueness does or does not apply is a somewhat subjective call. And that does seem to be the case here when the court is splitting 5-4, that they're reading this particular statute and saying, is this so vague as it should be overruled? 5-4 suggests it's a marginal call, and the history of this statute would suggest perhaps against it. I don't have any major objection to the majority in their ruling in this particular situation. Criminal defendants should be given every opportunity, and us being a country of liberty, we want to make sure that if things are illegal, it's clear to all what those illegalities are. But for now, my friends, this is all. I hope you're well. Until later, cheers and goodbye.